Hi daily update and I will share and subscribe to my YouTube channel no like. Abusua ni nkomo enra Supreme Court ekwa setina na or dismiss a injunction application a citizenship and organization be at the Kwada Supreme Court. Now I don't know what you know that's right after that dismission. That was enra Chief Justice na ankasa Torkono I suspended no. Ono ankasa file a interlocutory injunction o siki say Justice Pwaman or chair for the committee no omunyi two or sa siki say the Prima Facie case establish against no sa Prima Facie case no there is error on that. It is Chief Justice Torkono the akoda Justice Baffoe but now Evans Kasem say table can surely turn because it may be a term no panel judges to sit on case and a Baffoe and a bam panel and may sit on the case and so. The answer Chief Justice Pacho say Justice Bonny and I say Justice Bonny on a acting CJ say Australian Justice Pwaman on withdrawn from the committee of her probe. Secondly, so Prima Facie no wrong. Abusua yenkotie details joy.
5 p.m. When those who were pushing it filed it, we got to know for the very first time that the Chief Justice herself has now taken a suit at the Supreme Court, a court that was the boss of the judiciary until she was suspended. She's now taking a case to the Supreme Court, asking her colleagues to now make a decision. Remember, this is a very fascinating twist indeed to this whole scenario. Now consider the Chief Justice, who until very recently was the boss and empaneling judges. All the judges who have been sitting, she was their boss, and she told them what to do, and they did it. Which cases to hear, and they had it. Which cases they should sit on, and they simply did it. Now, the acting CJ will now have to empanel colleagues to hear the case of Justice Torkono. And this is very fascinating. This is the first time that she herself is the plaintiff in the matter. She herself, the Chief Justice, now a plaintiff in the matter before the Supreme Court, where she used to sit in judgment of others. Others are going to be sitting in judgment of her. That's a fascinating story tonight. And there's a lot to unpack here. Because of what she's asking for. A lot of them very fascinating. Many of them, I must say, majority, we are used to that. All the 5 suits I've talked about are very similar, largely asking the same things. And you wonder, but why? You go, you lose, you go again. Essentially asking for the same relief, making the same arguments. But there are a few additional reliefs that she's asking tonight that are new. We'll go to that when we sit down for a conversation. But she's taking this case against the Attorney General, Justice Pwaman, who chairs a committee investigating the matter, and Justice Adibu Asedu, who is the other Supreme Court judge on the committee. Daniel Demelebo, you know him, the former Auditor General, who is also a civilian member of the committee, another member of the committee who is not a judge, Major Flora Adulogo, and of course Professor James Jisa were all members. So she's actually challenging the committee's mandate to say that they shouldn't be allowed to go ahead. And we'll get into her reasons for that pretty shortly. A few of them, there are like 16 reliefs she's asking for. I can't tell you all, but let's go to the essential ones because you can summarize them into blocks, right? Because a lot of the reliefs are repeated, quoting different laws to back it. But the first fundamental one, the new one, is the fact that she's asking that the public, the hearing should be held in public. That there should be a public hearing as far as the proceedings are concerned. That we should take cameras into the room and so we can all see what is happening there. As a journalist, I would love that. It will make for some great drama. But this is a constitutional matter. It isn't one that you can just decide not to do. Her in-camera rights, right? Is it her rights to weigh, or the Constitution really gives no room to maneuver on the subject? Our lawyers will join us for a conversation on that. And then she's also saying that the Prima Facie determination that was done was improper. Why? We'll see. when we sit down to expand on the matter. And then also, she's also saying in the reliefs, as part of the reliefs that she's put before the court, that the members of the committee, all of them, including the, as I mentioned, Pwaman, who's the chair of the committee, shouldn't sit. Why is he asking that? Because he had been a judge in another matter and had ruled in favor of that individual, who now is a petitioner in the case to remove the CJ, right? And so he should be disqualified from sitting in judgment on that particular case. So that's a very fascinating one indeed, too. We'll get to look at everything else that she's asked for. And then there are two cases today, as I said, that have now been decided by the Supreme Court. All of them asking the same thing, trying to stop the process and get her suspension suspended, right? In both cases, the Supreme Court decided 4-1 that there was no merit in the release that they're seeking and the evidence backing that. So all of them have been dismissed. We're waiting to see when this latest one will be heard. But another fascinating thing for me that I look for today, there's a drama of it. When the other case was called, the Chief Justice as a lawyer for the very first time was in court. And questions were asked, was the Chief Justice herself there? Because obviously this is a matter that she is the main character in. And she wasn't, but the husband was there representing her. I mean, how fascinating would it have been for her to now come into a court that she used to sit in judgment and she was a boss of, to now appear before her colleagues and to be judged, right? My guests are joining me. All the twists and turns, fascinating indeed on charted territory. We're going to unpack all this. And then we are learning tonight that on this particular matter, the Chief Justice has hired the former Attorney General, Godfrey Adame, to be her lawyer. Again, another major twist. It changes a lot for those who watch this very closely, right? Because factually, the president nominated her, subsequently became the Chief Justice. There's no way the president would have nominated her without an input from the Attorney General, Godfrey Adame, who was there at the time. And so that raised a lot of questions. So there's a conflict of interest, possibly. He, obviously, having played a role in the Chief Justice's appointment, is interested in keeping her there, and that's the accusation. And that many also say, because she now has gone for Godfrey Adame, then clearly now puts it beyond doubt that she may be aligned now, or she is indeed aligned to the new Patriotic Party. Godfrey Adame disputes that and says, well, but look at the petitioners. They have lawyers who are known to be affiliated with the NDC, and they have taken their side. They've pitched their tent in the camp of the NDC. So, yeah, why not? But then that raises fundamental questions about the politicization of this entire process, which should have been purely a constitutional matter. My guests will weigh in after this. I wanted to hear your thoughts on one fundamental relief that the Chief Justice is asking for. I want to bring him in now, Mr. Sansari. There's one interesting relief that the Chief Justice is praying the court to grant her. She says she is entitled to waive her right to the in-camera hearing, if you may. The Supreme Court, the Constitution is clear that this process must be held in camera. But she says that she believes there's a case to be made for a public hearing. What do you make of the argument? The right to an in-camera hearing can be waived.
Well, she's trying to exercise her discretion one way or the other. Now, the stumbling block is that the Constitution does not allow a procedure other than in-camera hearing. And therefore, this is not one of the instances where the Supreme Court can waive that procedure. I think that it's so entrenched that for now, unless it is amended, for now, it has to be held, the proceedings must be held in camera.
Okay, Abraham Oliba, weigh in on this for me. Do you agree with her
that it should be waived? No, I do not.
Sorry. Forgive me. Forgive me just a second. I'm actually asking that of Abraham Amale, but stay with me. I'll come back to you pretty sure. I'm just running this by the rest of my panelists. Abraham, what do you make of that request for this hearing to be in camera?
The request is to enable us because the Constitution provides for how these matters are to be dealt with. And so you have no discretion to decide to, as it were, breach the Constitution because you feel that you want to waive that right. That right, if it's granted, amounts to she and the Supreme Court colluding to breach the Constitution. And I think that is why the Supreme Court would have to guard against.
Okay. So stay with me. I want to bring in John Darko. John Darko, give me your own thoughts on this.
All right. Thank you. Good evening to your viewers. I think it's very interesting that when it sees us, we think that the Constitution is so entrenched, and when it doesn't, then we believe that we can step aside the constitutional provision. But in this country, less than 2 weeks ago, when the president left the country, when he knew that the Speaker of Parliament was not in town, the Vice President was not in town, the constitutional provisions and the case of the same Asari Attorney General, the Supreme Court had interpreted the provisions so clearly that you couldn't leave the country without swearing in either the Speaker of Parliament to act. But the President left the country breaching the constitutional provision, violating the constitutional provision, and we didn't hear our brothers, or at least the panelists here, condemning the breaching of the constitutional provision. And so sometimes I wonder why we always want to do this to ourselves. We want to treat the Constitution, as if it's a convenient document.
Is there a constitutional? Is there a constitutional basis to waive that clause that says this process must be held in camera?
So look, if you look at Article 146(a)(8), which talks about the fact that the committee shall sit in camera, I think it is the basis for which my co-panelists are saying that the provision is so clear and that we cannot do anything about it. But we know that this same Supreme Court, our Supreme Court, has interpreted SHA, okay, because we are talking about the fact that the Constitution says it shall be in camera. The Supreme Court has interpreted SHA to mean not that provision may not necessarily be binding. I mean, in the Akufo-Addo and Mahaman's case, we know how the Supreme Court interpreted SHA. And so the fact that Article 146(8) says that the whole act shall be held in camera does not necessarily mean that we cannot interpret that to mean that this should be open to the public. Look, this is a matter of public importance. And if you look at our provisions, Article 281, this is more like a public inquiry. And the law is very clear that when it comes to public inquiry, unless it's going to be against public order, public morality, or public safety, these kinds of hearings must be in public. And so I don't think that it is so rigid, so difficult that we cannot grant that request. Look, I think that it's in the interest of justice. The people of Ghana deserve to know what is going to go down in this historic action that has been taken by the president. Look, we've seen the Supreme Court at least opening up our courts to camera, to public. We know in the two election petitions, the courts decided that they will hold the thing in public, even though our courts, are not allowed to broadcast trials, in public. But because the Senate hearings were always, in camera. And so it is not too difficult. And if you look at 1468A, again, my position on the law is that the fact that the provision says it shall be in camera doesn't mean that we cannot interpret that to mean that we can have it in public.
Abraham Alaba, John Darko has a point, isn't it? That even if you just go beyond the constitutional provision itself, what do you lose if you open up this committee hearing to the cameras? In fact, don't you rather gain transparency? You actually gain a bit more openness to the process, and that citizens can then follow, and you'd then rule out the possibility that this may be misconstrued in the eyes of the public. This is good for democracy, isn't it?
Democracy is different from what the law is. The law is not democracy. Democracy is not a law. These are two different things. Good governance is what you are talking about, but the law is the law, as the embattled Chief Justice said. Clearly, the Supreme Court is under the Constitution. The Supreme Court is not above the Constitution. The Supreme Court can only do what the Constitution says it can do. The Supreme Court cannot do what the Constitution doesn't say it can do. And so, if we are advancing the argument that even though the Constitution stipulates how these matters are to be dealt with and says that the hearing must be in camera, but the Supreme Court should go beyond the Constitution, then we end up not having a Constitution at all. And we can't just say that we should allow the Supreme Court to do what it likes.
But what real purpose does it serve to have this in camera when the person who is accused says, I'm ready to waive that?
I want to believe that the framers of the Constitution were of the view that such matters, because of the position of the Supreme Court, there are some information when it is leaked may have some negative impact on the country. Probably matters of national security, the same things that my colleague is talking about, public health matters. We don't know where it will touch. We don't know which of our life as a country that this may negatively impact. And so the framers of the Constitution, I'm just thinking for them, may be thinking that because you don't want to spill those things in the public domain, it should be held in camera. The issue that in the past the Supreme Court, or is it the courts, did not allow cameras into the courtrooms, but now we have it, is different from this. In that situation, we didn't have provisions proscribing the use of cameras in our courts. It was just a practice, and so you could easily do away with the practice. But in this one, it is clearly stated, and you cannot. You could have as well said, okay, the two justices should also sit. We should go and bring justices from other country. Or we could say, but the Constitution has stipulated how, the way and manner in which this must be done, and you have to respect it.
But Counsel, if I may just chime in,
please.
See what is happening here. What is happening here is not going beyond and above the Constitution. I think that what is happening here is just interpretation of Article 1468, which says that the committee shall sit in camera. Okay, so just interpreting that provision, and we know, like I said in the Akufo-Addo and Mohammed's case, the 2013 case, the Supreme Court interpreted SHA to be permissive. More or less, SHA is not mandatory and that it could be permissive. So we can say that the fact that SHA is there, the fact that 146 says SHA may mean may. And so it is not necessarily binding and that they can waive it. Our Supreme Court interpreted SHA in 2013. They said that it doesn't necessarily mean that SHA is compulsory and that we may interpret that to mean may. And so let's let's instead of shall, let's put may there, and you see that it will read nicely, and the Supreme Court can easily say that, okay, we will give you the right to be heard in public. And so there's an option. We cannot say that there's no option because of the way 146A is, crafted.
No, that type of interpretation is not done in just, where may is interpreted to mean shall and shall may. No. In situations where a person's rights would be affected, that is when you would interpret may to mean shall. So, for instance, if you say you may, after a committee hearing,
somebody's right will be affected?
After a committee's hearing, you may give Evans Mensah the proceedings of the hearing. Then you say, oh, it says may. But you know that Evans Mensah needs that report to mount a case in court. At that point, the court will say it's a shall. This one, how would the hearing in camera affect her rights? How would that affect her rights?
Of course. I mean, the people of Ghana need to know.
It's not about
wait, my brother. She's been accused of so many things, okay? And already we all know, you and I know, that the petitions are in the public domain. And so people want to see how this should be proven before the committee. People of Ghana, for whose interest and this justice is done, need to know, because this is, and let's be careful. This is the first time one head of the arm of government is being removed. The people of Ghana deserve to know. They want to follow what is happening. And she herself will want the people of Ghana to know her position, because she's been disgraced with all these petitions. She wants to prove her case in court. I don't think that.
John Darko, stay with me. Let me bring in Asasari. Mr. Asasari, is it her right to waive?
Hello?
Yes. Is it her right to waive?
The lady Chief
Justice, yes.
No, the Constitution doesn't put, the applicant, to an election to elect whether to waive or not to waive.
She's the accused in this case, and she has everything to lose, right? So you think that this clause was put there in the interest of natural justice and also in protecting the rights of the Chief Justice in case anybody triggers it. Isn't that her right to then waive if she doesn't want to?
No, the answer can be found in Article 125. It says that even though citizens' participation in the administration of justice must be encouraged, it is subject to the Constitution, and therefore the independence of the judiciary is itself subject to the Constitution. As a clear language of Article 125 of the 1992 Constitution. Now, remember, Kofi Kumado once said that democracy is not synonymous with constitutionalism. So the two are different. Yes, democracy, but the Constitution, speaks in peremptory language sometimes when it's served. Then thirdly, I think this is one of the instances where ACTA will describe, the operators of the Constitution, as not only subject to the Constitution, but also.
And then I will show you Medina. Now, subscribe to my YouTube channel, like and share. God bless you.